Okay, Assalamualaikum and good afternoon, students.
Afternoon,
Hello,
madam.
students. Okay, good afternoon to all. Okay, for today's class, I'll be introducing industrial action, okay? And also, if possible, we try to finish. Okay, can we start the class?
Yes, madam.
Yes, madam.
Okay. Okay, for the definition, what is industrial dispute? Okay, so Section 2 of the Industrial Relation Act says that industrial dispute is any dispute between an employer and his workman, okay, which is connected with the employment or non-employment or the terms of employment or condition of work of such workman. Okay, so it can relate to the employment, okay, or non-employment, okay, and also the terms and condition of employment. That means anything, any dispute between employer and workman, okay, it may be connected to his employment or work, or something to do outside the employment, okay, or it can be also terms and condition of employment, okay. So that's the definition. So the definition is very broad because it will also include non-employment, but it must be within the relationship of employer and also the workman, okay. So the industrial action that we're going to look, or the disputes that we are going to look between employer and employee, are restricted to the three kinds only. That's strike, lockout, picketing, okay, and intimidation is left out, because it is not in the syllabus, but just to let you all know that there's intimidation under Section 39 of the Industrial Relation Act. Okay, so have you all heard about strike before this?
Yes, madam.
Okay, so if anyone have like photos or video on strike, you can put in the group, so that students, I mean your friends, will know what is strike. Okay, I mean according to the video or the photos. Okay, so strike is like sometimes I can't say that it's sometimes, but it's it happen. Okay, it happened in US, UK, Australia, India, but very seldom in Malaysia. Okay, so what is strike? So strike is the cessation of work, okay, by a body of workmen. Okay, that means the stoppage of work by a body means a group of employee or workmen. Okay, where they are acting in combination or under a refusal and under a common understanding. Okay, um, refusal to continue to work or to accept employment. Okay, so it also include act or omission by a body of workmen, okay, acting in combination or under common understanding, which is intended to restrict, reduce, or cease in the performance of the whole or part of the duties. Okay, so it's very long. Okay, it means that there's by a group of workmen. You cannot strike alone. That's the understanding from the definition here. You have to strike in a group, okay, where it can be refusal, okay, or to accept employment, okay, between the group of the workmen, where there's a number of workmen, okay, a number of workmen, okay, that means they refuse to continue to work, okay. That means it's a stoppage here also, then refuse to continue to work, okay, by a body of workmen, okay, where they have the common understanding that when they refuse to work, that means it will intend to restrict or reduce or cease the performance of, okay, or partly, okay, their duties as a workman. Okay, that means you are not going to work during strike. Be restricted. Okay, maybe can be going to strike in the evening. That means you might going to work in the morning, or you're going to strike the whole day, where it's going to stop, cease the performance of the whole or part of the duties. Okay, can you all understand the definition? What is strike?
Yes, madam.
Anyone else? Arisa says yes. Okay, that means employee are not working. They are at the workplace, but they are not working. Okay, so but they are not working means they have restricted their work. They have reduced their performance of duty, or they are not doing their duty at all. I mean the performance of their duty. So it can be is intended, okay, either to restrict, reduce, or cease in the performance of the whole or part of the duties of the group, a body of workmen, okay, where it must be a number of workmen. Okay, so you cannot strike alone. Okay, so one famous case, Southeast Asia, Sendra Berhad versus Non-Metallic Mineral Products Manufacturing Employees Union, okay, or is known as Seabricks case, okay. Case because this is the first case in Malaysia regarding strike, okay, and we don't have many cases. I think not even 3 cases on strike, okay. Okay, so according to this case, employees of the company, non-metallic mineral products, okay, the employees of the company went on strike over a refusal of the company to accept the employees' invitation to commence a collective agreement or collective bargaining. Okay, for the collective bargaining, we have to send the invitation in writing to the employer, where the employer have employees' invitation to commence a collective bargaining. Okay, so that's the reason why the employees go on for strike. Okay, so what the company do is that because the employee goes for strike, okay, the company issue a notice that the work stoppage was not a strike but a break in service. That means when you strike, that means you do not perform your work. Actually, there's a break in the relationship between the employer and the employee. Okay, and then the company saying that they have to, the employees have to return to work within 48 hours. If not, their service will be terminated. Okay, so this is the reaction of the company. Okay, since the employees are going on strikes, the company says that okay, you have to come back to work. If not, the company will terminate. Okay, so what happened to the employees? So the employees carry on strike until they were informed the matter has been referred to the industrial court. Okay, so if the matter has been referred to the industrial court, the dispute has been referred to the industrial court, the employees cannot go for strike. Okay, because they have to wait until the hearing of the industrial court. That because there's a provision under the law that says that if the matter is pending at the court, the employees cannot go for strike. Okay, so when the matter was referred to the court, the employee employer, okay, but the employer refused to take them. Okay, so you can see here, okay, what happened to the employee. Okay, so the employee have no work, okay, because the employer refused to take them back to work. So what do you think the decision? Okay, the court says that. The strike matter was referred to the court also by the employee. Okay, so the employee was said to be, okay, um, I mean, said to be commence the strike lawfully. Okay, so the court decided the strike is lawful. Okay, even though the employee has absent from work more than 2 days, it cannot be regarded as a breach of employment contract, because they have followed the procedures before they go on for strike. So the employees here or the workmen here have serve the notice to the employer before they go on for strike. So the strike is justified by the law. Okay, so since the strike is lawful, okay, do you think the employer have to take the employee back to work?
I think they have to because the strike is legal.
Okay, yes. Okay, so thank you, Ichin and Nurul. Okay, so the court says that, okay, the employer cannot refuse to take them back because the strike is lawful. Okay, there's no breach of contract. Okay, so that's the decision of the court in this case. So this is a very famous case for the strike in Malaysia. It's a landmark case. That means it's the first case that court decided. Okay, so you have seen in the previous cases, Seabriggs case, that they have given notice. Okay, so you will see what is the requirement for strike under the Industrial Relation Law. Okay, so Section 43 of the Industrial Relation Act, okay, says that notice must be given, okay, in strike if it involves essential services. Okay, so what is essential services? We'll look after this slide. Okay, so we will see the length of the notice first. So the workman cannot go for strike, okay, without giving notice. That means the workman have to give notice, okay, notice to the employer regarding strike before within that means they cannot strike until they give a notice of 42 days, okay, or within the 21 days that they give the notice, and this 21 days is within the 42 days, okay. Within 21 days of giving notice, the workman also cannot strike. No workman shall go on for strike. Okay. So here is the length of the notice. Okay. So even though notice has been given, within the 21 days, the workman cannot strike. Because this is for the workman and the employer to negotiate for settlement. Okay. Okay, so what is essential service? Essential service has been listed under the first schedule of the Industrial Relation Act. And the act here is Industrial Relation Act, which involve banking services, electricity services, fire services, port, dock, harbour, airport services, and undertakings, postal services. Actually, the list is long. Okay, prison services, production, refining, storage, supply, and distribution of fuel, lubricants, public health, okay, telegraph, telephone, telecommunication, water services, and etc. Okay, so in this kind of services, essential services, if they strike, they have to give notice. Okay, that means you can say that all the um, what do you call services actually need the workmen to give notice to the employer before they go on for strike. Okay, so you can imagine if let's say the hospital employees, public health service, the hospital, government hospital, nurses or maybe doctors go on strike, what will happen to the country? Okay, so they have to give notice, but the notice period is very long. Okay, because the industrial relation department will initiate for settlement within the time frame. Okay, that's why in Malaysia we have few strikes and cases being referred to the court also is very few. Okay. Um, any other question you want to ask me so far?
So far, no questions for me.
Okay, thank you. So okay, thank you for those who have answered. Okay, so beside notice, you cannot, even though you give strike, there's a time limit that you cannot strike. Okay, there's also another provision, section 44, prohibits strike in any of the following circumstances. Okay, again, you cannot strike during the pendency of the proceeding of a board of inquiry under Part 8, and set the conclusion of such proceeding. So part 8, we will see later, is about any dispute that referred to the board. Okay, so because they are going to investigate, so you cannot go on strike during the pendency. Okay, during the that means waiting for the proceeding to be completed. Okay. So another situation is after a trade dispute involving such workmen, an employer has been referred to the industrial court and the parties has been notified. Okay, the situation is same as in the fire breaks case. Okay, that's why the employees go back to work because they know if they're going to strike, then the strike will be illegal because they are prohibited from strike. Okay, other situation is where if it involves public sector, okay, after Yang di-Pertuan Agong or state authority has withheld consent. Okay, that means the Yang di-Pertuan Agong or state authority do not consent to the strike. Of course, you cannot strike. Okay, that's the rule here. Okay, because the matter has been referred to the industrial court. Okay. Then any matters in the collective agreement, any matters covered by a collective agreement taken approved by the court. That means given cognizance by the court because the matter is clearly stated in the collective agreement. So you cannot strike on matters which is covered in the collective agreement. If you dispute or if there's a non-compliance, the parties have to refer to the industrial court. Okay, so you cannot strike on that matter. Again, in respect of any matter covered under section 13, subsection 3. Subsection 3 is regarding prerogative of management. So you cannot strike on the prerogative of management because the employers are given certain privileges. Okay, so there's a 5 condition under section 44 where workmen cannot go on for strike. Okay, then there are also other circumstances in the following section, section 41, section 45, subsection 1, where a strike shall be deemed to be illegal. Okay, this is straight away illegal. Okay, the other section says that it is prohibited. Okay, but section 45 says that it's illegal. Where it is commenced in contravention of section 43 and 44 or any provision in any written law. Okay, that means if you do not follow section 43 and 45, automatically the strike shall be illegal. Or if you commence strike in contravention of any provision in any written law, that means any other law beside Industrial Relation Act or Trade Union Act. Okay, then it has any other object than the furtherance of a trade dispute. That means the strike must be related to trade dispute, if you have any other reason why the strike has been commenced, okay, that means other reason than the furtherance of a trade dispute, then the strike shall be deemed to be illegal. You know that under section 2 just now, we have seen strike is a trade dispute between employer and employee. So it must be because of a trade dispute. Okay. This is subsection 1. Then subsection 2 of section 45 says that a lockout declared in consequences of illegal strike shall not be deemed to be illegal. Okay, so you will study lockout later. If the employer is going to declare lockout, okay, then the illegal strike, okay, because of an illegal strike, so the lockout shall not be deemed to be illegal. Okay, so you will look at lockout later because it's I cannot explain everything on lockout now. Okay, so what is lockout? Okay, so before we move to lockout, are you clear with what is strike now?
Yes, madam.
Mm-hmm. So can you give any reason that can cause strike in Malaysia,
Uh,
or you have
any
known?
trade dispute, right? Maybe
Yeah,
it was
any.
something doing with working conditions.
Mm-hmm. Okay, working condition that you think can cause a trade dispute is like what?
Maybe related to safety and health.
Mm-hmm. Okay, the employees are not satisfied. Okay, with safety provisions not complied by the employer. Okay, then we got one case, one reason from Southeast Asia's case where employer refused to accept the invitation to commence collective bargaining. Okay, any other reason? Any other reason that you can see that can be a reason uh, why employee wants to commence strike? Any trade dispute you think? Okay, underpaid, that means the employees are not getting minimum wages. Okay, who I just saw the last name Ahmad. Okay. Failure to pay workers, okay, if you do not pay, because we got so many cases like the railway and trade unions where they are not paid salary, or they are not given better pay, okay, they go on for strike. Okay, if the employer do any contrary to the contract terms, okay, so it can be, so you must mention what is the contrary terms, like maybe not paying salary, not paying bonus, which has been stated, okay, between in the contract of employment. Okay, maybe the employer want to change the working hours. Okay, so any reason that you think is related to terms and condition, so you must know, okay, what is the term and condition. Okay, so in the
Madam,
case, yes.
questions.
Mm-hmm.
What about the unfair dismissal? Can it be viewed as a trade dispute?
No, because it's by a person. It must be trade dispute is sorry. The strike must be in where it's done by a group of employee.
Okay, what about retrenchment? Like maybe they did unfairly.
Okay, retrenchment can, let's say the employer want to retrench maybe 200 workers. Okay, so the employer did not discuss any of the terms, and suddenly the employees are given that 1 week notice saying that okay, next month we'll close the company. Okay, or maybe the company will be closed in next 2 months. Now the company is unable to pay salary, you will be on leave, unpaid. You'll be on leave without any salary. Okay, so it can be a reason. okay, where for retrenchment. Okay, so they have the reason that the trade dispute is regarding the procedure for retrenchment has not been followed by the employer. So the employees are not happy, they go for strike. Okay.
Okay, thank you, madam.
Okay, so we look at what is lockout. Okay, so when there is strike, okay, strike is by the workmen, a group of normally it will be in group because you cannot strike alone. Is does not fall under the definition. So it will be like 3%, 10%, 20%. So when the company is facing the strike, okay, by a group of workmen, okay, so the company would do something, okay. uh, Normally when before strike, of course you are not happy, you go and see the employer refuse, okay. And maybe sometimes he also will negotiate the terms and condition what you are not happy, okay, will talk and settle. But some trade union or some group of employees, they do not want to settle, okay. So the law allows the employer to lock out. Okay, lock out is where the employer will close a place of employment. He will close the business, okay, or he suspend the workers from work, or the refusal by the employer to continue to employ a number of workmen employed by him. That means those who are going on for strike. Okay, so he can refuse to employ the particular group. Okay, in furtherance of a trade dispute done. Okay, he is doing all this. One, two, three. Done with a view to compelling those workmen to accept terms or condition of employment. Okay, so when the group of workmen go on for strike, the employer will go for lockout, because he wants the matter to settle, the trade dispute between the employer and employee to be settled before the matter is referred to the court. Okay, he can lock out. Okay, the reason is that he want to compel those workmen who are going on strike to accept the terms and condition of employment and settle the trade dispute. Because if the matter goes on to the court, okay, the employer, okay, will be facing a lot of, um, loss. That means that business will not be going on, and the employees also will be in lose side because they will not be getting any wages unless the strike is legal strike. Okay, so lockout is by the employer. Okay, so can you understand what is lockout?
Yes, madam.
Okay, thank you. So lockout is where the employer closed the workplace. That means he locked the main gate. Maybe he suspend the work. That means okay, the next 3 days no work for all the employees. Okay, or he can focus on the particular group, the group that go on strike. Refuse to employ the particular group that go on for strike. Why he's doing this is that he want to compel those workmen who going on strike to accept the terms or condition of employment. Okay, so he cannot do without any other intention, but it must be in furtherance of a trade dispute. That means there is already a strike, then only the employer can go for lockout. Okay. Okay, so the requirement for lockout is also the same. Okay, but it's very difficult for the employer to do lockout because he also have to give notice. If the employer give notice for, let's say, the minimum 21 days, what will happen to the business? Okay, so it's very difficult for the employer to go for lockout. You must remember, because he also must give notice to the trade union or the group of employees that going for strike. Okay, so it's the same. Same section applies because the section reads as strike and lockout. Okay, then there's section 10 also under the Industrial Relation Act, which prohibit the trade union, okay, on strike, lockout, picketing, and termination of service pending recognition of trade union. Okay, this is especially for the trade union. The trade union cannot go for strike in the circumstances mentioned in section 10. Okay, I think this has been explained earlier also. Okay. Okay, then provision under the Trade Union Act, okay, regarding strike and lockout. Okay, so before strike and lockout, the trade union, okay, have to get consent by secret ballot by at least 2/3 of the total numbers of the workmen who are the members. Okay, so it's not easy to strike because at least 2/3 of the members of the trade union must consent, and he will do it by the trade union will have to conduct secret ballot. Okay, undi sulit, okay. Then before the expiry of 7 days after submitting the result of the secret ballot, the secret ballot here to the Director General. Okay, that means after the secret ballot result, 7 days you have to submit the result to the Director General. So you have to wait until the expiry of 7 days, because before the expiry of 7 days, you cannot also strike. Okay. Then if the result of the secret ballot has become invalid by virtue of the other sections, also no strike or lockout. Okay. So then no strike, okay, if you do not fulfill the rules in trade union in respect of matters covered under the direction of minister or in contravention of any other written law. Okay, so this the provision um, is under is stated in the under the Trade Union Act section 25. Okay, so you can see there are other reasons. Okay, you have to get the consent by 2/3 of the members. Then you have to wait until the expiry of 7 days. Okay, and then the secret ballot also have to be valid. If it is invalid because of section 40 subsection 2369, then the trade union cannot call for strike. Okay, let me see whether I already put the section here. No. Oh yeah, it's here. Okay. Okay. So section 40 is on the rules of the secret ballot. How you have to conduct secret ballot. Okay. This section, section 40, subsection 2369 is where the procedure to conduct secret ballot, okay, must be complied. If you do not comply with the procedure, then the secret ballot become invalid. Okay. Okay, so this is same under the strike also. Okay, when strike is not permitted. Okay, I think it's redundant here. This slide, okay, it's redundant. Okay, the secret ballot under section 40. Yeah, okay. So trade union shall take secret ballot. Okay, uh, for the following matters, and especially all matters relating to strike and lockout. So the requirement for secret ballot is stated in section 40, subsection 1. Okay. And the secret ballot shall contain a resolution setting out clearly the issue leading to the proposed strike and lockout. Okay, so why workmen want to go for strike? You must have a resolution. That means it is like in paper. Okay, the reason must be stated clearly why the workman wants to go for strike. Okay, and then the secret ballot also shall cease to have effect on expiry of 90 days after the date on which the secret ballot is taken. Okay, That means the secret ballot is valid for 90 days only. Yeah? Okay. Then the result of the secret ballot shall be submitted to the Director General within 14 days. Okay, so you cannot wait until after 14 days. You want to submit to the Director General, you cannot do that. Okay. Then the Director General shall carry out investigation upon receipt of the result. If he is satisfied that the proposed strike law art will contravene any law, he shall direct the union not to commence. Okay, so the Director General, after looking at the proposed strike, that means the resolution, okay, he shall give his opinion. Okay, and the secretary of the trade union shall take all necessary steps to ensure that all ballot paper and document used in connection to the secret ballot are kept at the registered office of trade union for at least for 6 months. Okay. Then the director may in any particular case declare a secret ballot to be invalid if he is satisfied that the trade union has contravened any provision of the Trade Union Act or any regulation or any rules regarding secret ballot. Okay. So the procedure for secret ballot is stated in Trade Union Act. Okay. Any question?
Madam, questions.
Yes.
Let's say that if the employees go for the strike, right?
Okay.
Can the employer also declare a lockdown at the same time? If he already comply with all the provisions, such as giving notice.
Mm-hmm. He said he have to give notice for 40 the maximum within the they cannot strike okay within the 40 is it 42 days or 41 days
42.
42 days 42 days okay, if you look at the provision, is it logic for the employer to go for lockout where he have to give notice for such a long period?
I think it's not logic, yeah.
Because he's doing business. Okay, unless it's very serious strike. Okay, it's more than 1 month. Okay, so that's why it's very difficult. Okay, to go for strike and even for the employer to do lockout. Because for strike, so you have to go, you have to do the resolution, you have to take the secret ballot, then you have to give the notice to the employer. You cannot strike within 21 days, and then you have to strike within the 42 days. I think since the what do you call the old case is Seabricks case is very long ago. I think more than how many years? It's already like 40, 50 years ago. Okay, so it's very difficult to go for strike and lock out. Okay, in Malaysia. Okay, unless the employer is very stubborn and the employee also do not want to accept any what do you call cause what do you call negotiation between them. They cannot negotiate and then they cannot settle, then only the matter will go on from strike to lock out. Okay.
Okay, madam.
Okay, thank you. So the penalty for illegal strike and lockout. Okay, so if the both parties do not want to follow, okay, they shall be guilty of here it shall be liable not guilty. Okay, the workman shall be guilty of offence and shall be liable for imprisonment not exceeding 1 year or fine not exceeding 1,000 or both. Okay, and further a fine for every day. Okay, so it will be the same for the illegal lockout also. Okay, it's under the subsection. That means this provision is for the employer. You got one case. Okay, Hotel Jayapuri's case, where the court have to distinguish whether it's a lockout or a closure. Okay, so the court later found out that the employer, okay, have to pay compensation, okay, because in case of closure, the employer does not merely close down the place of business, okay, but the closure indicates the final and irrecoverable termination of the business that is going to close because of redundancy, okay. So the employer have to pay compensation, okay. So a lockout indicates the closure of the particular business as one of the reason, and it is not the closure of the business itself, okay. So you can read this case to know why the court have to decide whether it's a lockout or closure. Because in case of closure, the employer have to pay compensation to the um, employees. In case of lockout, okay, is because of trade dispute. Okay, so I think you can look for other cases because you'll get assignment on this topic, I think. Okay, then also old case, Wood Textile Mass Limit Sindra Berhad and Penang Pride Textile Garment Industry Employees Union. So the court in this case, the principle is that in the field of industrial law, the workmen are not entitled to wages for the period of illegal strike. Okay, but in case of lockout is illegal, the employer will be liable to pay full wages to the workmen. If the lockout is legal and justified, the employer will not be liable to pay, and the workmen will not be entitled to receive wages for the during the duration of the lockout. Okay, so the workmen have to make sure that they follow the procedures so that the strike will be legal. Because if it is illegal strike, the workmen are not entitled to any salary. Okay, so the employer also have to make sure that the lockout is legal. Okay, if not, he have to pay the wages to the workmen if the lockout is. Can you give the solution for this? If the lockout is legal, the employer will not be liable. So the employer still have to pay the wages, okay, if the lockout is illegal. It's quite difficult to make sure, okay, because the employer, okay, if there's a legal strike, that means the employee will get the salary, okay, and the employer also must do something which is legal so that he will not be bound to pay the salary to the employees. But nowadays, I think salary are paid monthly. It's not like during those days that in 1984 the salary is paid every 2 weeks and it is paid daily, calculated daily. Okay. You know, those days employees will get salary every 2 weeks. Okay, so it's different from now. Okay, so where you got salary every month. Any question?
So far, no.
Mhm. Okay, and we got one case from Sabah regarding dismissal of the claimant. Okay, um, um, I remember Yichin asked me a question whether dismissal can be the reason or not. Okay, here one person was dismissed, but that person is the one who instigated a strike. That means menghasut, okay, who want the other workmen to go on for strike. Okay, and at the time there was a pending recognition claim on the union. Okay, so the company has not renewed three union members contract. Okay, so the union application for renewal was rejected. Okay, so this was the reason why the employee workmen go on for strike. Okay, so the reason is because the service of three union member was not renewed. Okay, so can they go on for strike? So the court had that a strike shall not be deemed to be illegal under section 45 subsection 2 if it was declared as a consequences of a illegal lockout. Okay, this is the principle. Okay, and the workman has no reason to strike on the account of pendency of the recognition proceeding according to section 9 of the Industrial Relation Act. Okay, and then being a foreigner in this case, it involves foreigner. Okay, they cannot be a member of the union. Okay, so that's the decision of the court. Here, the claimant is a foreigner, so they cannot go on for strike. Okay, and then during the recognition claim pending at the industrial court, you cannot also go for strike. So the strike here is considered as illegal because they got no reason to strike. Okay. Okay, and then this is this case covers picketing also. Okay, so H.M. Shah Enterprises Sdn Bhd versus National Union of Hotel Bar Restaurant Workers. Also, all case you can see in 1980s, there are cases on strike and lockout. So the court says that in this country, picketing, strike and lockout are allowed, but within the confine of Part 9 of the Industrial Relation Act. The union will take picketing or strike action straight away. No union will take picketing or strike action straight away without negotiating or negotiation first having been entered into. What the union in this case has done in form of negotiation and then picketing appears to be well within the law and cannot be deemed to be arrest. Okay, so the court in Malaysia recognize picketing, strike and lockout, but it must be within Part 9 of the Industrial Relation Act. Okay, so in this case, the employees negotiate first. They deal with the employer, but since the negotiation failed, the employees went on picketing. Okay, so here the court recognize okay, picketing, strike and lockout. Okay, so another case on strike also. Okay, USA Batteries case says that workmen are under an obligation to procure normal and reasonable production, and if they deliberately refuse to give that production, they must be held guilty of misconduct of go slow. Okay, so go slow is not a trade dispute. So go slow has been considered by industrial tribunal to be sabotage of the employer's business, which can never be justified and which deserve the punishment of dismissal. Okay, so go slow is not a reason where the employee can go for strike. Okay, if you go for strike, it's not a go slow is not a strike. Okay, and it's a serious sabotage of employer's business, and it cannot be justified. Okay, and the punishment is dismissal. Okay, so very what do you call? You can see very strict. Okay, on this matter, go slow. go slow, that means you're going to do the production very slowly, so that the employer will not reach the target for the particular day. Okay, so it's not a trade dispute. Okay. Okay, got how many more slides for me to check? Okay, can we go on with getting? Okay, so the provision on picketing, if you look at the provision on picket, have you seen picket before in Malaysia? Picket by normally by the bank employees?
No,
No.
I don't.
Mhm. Picket is where the employees, okay, are doing their work. Okay, they go to work as usual. Okay, and they picket, okay, during their own time. Okay, so during their own time is during lunch, after work, or maybe it can be before they start the work. Okay, so picket is where the work will go on as usual. Okay, so in strike, there'll be a stoppage of work, reduction of work, but in picket, there's no disturbance. Okay, on the employer's business or the employee's work or performance. Okay, so section 40 subsection 1. Okay, if you read this sentence is like in negative, it shall be unlawful for a person or person acting on his or their behalf of a trade union or an employer in furtherance of a trade dispute to attend at or near a place. Okay, that means it is unlawful. Okay, um because of furtherance of a trade dispute to go to the place where the employee are working, or even near the place they are working. Okay, but it shall not be unlawful, that means they can do where one or more workmen to attend or um, um, near the place where the workman works, or where the trade dispute only for the purpose, okay, of peacefully. Okay, that means here is not unlawful for a particular employee or more than one employee to go to the place of work, or even to attend the place of work, okay, for the particular purposes. Okay, where you want to give um, information, you want to obtain or communicate information, or you want to persuade or induce any workman to work or to abstain from working. Okay, um, provided such attendance being in such a manner. Okay, here you can see that subject to such attendance being in such manner. That means he cannot do one and two. Okay, in the following manner: intimate any person to obstruct the approach thereto, or to ingress therefore, or to lead a breach of the peace. Okay, so uh, even though he is allowed to do, okay, provided is not unlawful to do all this, okay, um, one and two, but he cannot do in a manner which he breach A, B, and C. Okay, so it's quite difficult um for you all to understand, because the section is very long. It's in 2 slides. Okay, that means if you want to give information, or you want to be at the workplace, okay, you cannot intimate any other workers, or you cannot obstruct the approach thereto, or to the entrance or the way out of the company, or you going to lead a breach of the peace. That means you cannot cause any um, disturbance or breach of harmony at the workplace. Okay, so you are allowed to give any information. Here, the information, communication of information actually referring to the terms and condition or any matters regarding the dispute between the employer and the employee. Okay, um, maybe I can later give you some photos regarding Phuket, where they normally have the banner or maybe some streams, giving information saying that the employer have not paid wages or the employer have breached the contract, okay, or the employer business should be closed down. Okay, any information they can give, okay, they can obtain or communicate information, okay, or they can even persuade or induce any workman to work or to not to work. Okay, but the attendance of the workman, okay, cannot cause A, B, and C. That means they cannot close the entrance where they're going to picket. They cannot close the entrance of the company or the way out of the company, or they cause chaos at the workplace. They cannot do that. Okay, so they picket is where the employees are doing in a harmony way. Okay, the work continues. Okay, they can bring all the what you call the strict with the information, or maybe they want to bring the banner during lunchtime or after work or before work. They can do it. Okay, so picket is something is lawful. Okay, provided that they have fulfilled the provision under section 40 subsection 1. Okay. Okay, so during picket, section 40 subsection 2 says that any officer or employee of the trade union may be present with such workmen, okay, for purpose of maintaining good order and discipline and ensuring that such workmen comply with the requirement. Okay, so if any workman who act in contravention of the section 1 shall be guilty of offence and shall be liable for imprisonment for 1 year or fine of 1,000 or both. Okay, so during picket, the officer of the trade union may be with the workman. Okay, why? For the purpose of maintaining good order and discipline and to make sure that the workman comply with the provision under the law. Okay, so can you understand what is picket now?
Yes, kind of.
Okay, so if you can get a photo and picket, you can put in the group also for the students. Okay, so the provision regarding picket it also is about the same with strike, where they are not allowed to picket. Okay, under section 40 subsection 2A. When the matter has been referred to the industrial court or the matter has been referred to the board of inquiry, or whether the Yang di-Pertuan or state authority have withheld the consent. Okay, so last case, Syarikat Perjalanan Terus Batuan 1988 says that picket is one of the lawful weapon of workers. The limit for lawful picket are simple: picket in employee's own time, no disruption of the business of the employer, no offence committed in the course of picket. So in this case, there's no complaint by the company of any offence. Okay. So picket is where you picket in employee's own time. That means during lunch, before work, or after work. Okay, and you cannot disrupt the business of the employer. Okay, so if you can do this, no offence committed in the course of picket. Okay, students, any question? I think we can stop here.
Okay, madam.
Okay, so it's No break. It's a bit tiring. Straight away from 3:40, nearly 1 hour. Straight away without any break. Okay. So I hope that if you can get some photos on Strike and Picket, you can put in the group. Anyone, you can have few so that you can get the idea what is Picket, what is lockout, what is Strike. Okay, the provision regarding the requirement for Strike lockout is the same. Only for Picket is under Section 40 of the Industrial Relation Act. Okay. So if there's no question, I think I will stop here. Is it today the last day to submit your assignment one?
Yes, madam.
Mm-hmm. Okay, so I cannot what do you call it must be in the because it is in group. It's quite difficult for me to detect who is not in the group. So make sure that you do not leave out any of your friends' name, and make sure all the members has given cooperation. Okay. So please submit to the or upload at the portal. Okay. So thank you very much. Okay. So for those who have not, I still give you some time. You see whether you can scan your attendance or not.
Thank you,
Okay. So
madam.
yeah, welcome. So happy weekend.
Thank you, madam.
Okay. Bye.
Only one member submit the assignment, right?
Again.
Only one member submit the assignment, right?
Assignment one. Yes.
Only one member submit the assignment.
Yes. Only one member. Anyone who is the leader of the group. Okay.
Thank you, madam.
Okay, welcome.
Thank you, madam.